Hi, Assalamualaikum Madam Asma. My name is Muhammad Firdaus bin Saifuzain, and along with me are...
Hi everyone, my name is Muhammad Shoraika bin Muhammad Soimi.
Assalamualaikum and hi, my name is Nawadiha binti Muhammad Shukri.
Hi, my name is Umi Dayana binti Imandi.
And we are from group number 1, are going to do an oral presentation pertaining to the assessments given for us. And since the question given have two, the first question will be handled or be discussed or by solved by me and also Shahrul, while the second question will be handled by Wadiha and also Umi Dayana. So without further ado, let's just proceed to what kind of advice that we're going to give for our party.
The issue that arises in this question is that whether Radi and Tora have their rights and interests to the land after Mr. Manilingam had made fraudulent action to Radi's land and transferred it to Tora. Jual janji is a loan transaction of loan that will be done by the lender to the borrower. Such a transaction was solely derived from the Malay Muslim community in order to provide security to the lender. The borrower will transfer the land to the lender as per promise that they will pay back the loan that they have obtained. But throughout the times, the legislative body in Malaysia had recognized jual janji as customary tenure pursuant to Section 4, Subsection 2, Para A of the National Land Code. The purpose of the existence of jual janji is to make sure that usury can be avoided. This can be referred to the case of Tengku Zara against Syed Yusof, where Lord Briggs said at page 3, whereby the whole purpose of jual janji transaction is to provide a procedure for securing a loan without infringing the prohibition of usury, which is a binding to the conscience of all good Muslims. The reason for this is because the process of jual janji during those days requires no documentation of the agreement to jual janji by the parties. Nowadays, it is mandatory for jual janji to be registered, where the borrower shall fill out Form 14A as in National Land Code, which is necessary for the transfer of land, share or lease, and show that there is actual transfer of land on behalf of the borrower to the lender. Furthermore, in order to ensure the process of jual janji to be valid, there shall be certain elements that firstly need to be identified and fulfilled by the parties. The first element of jual janji is that there shall be lender to the loan. The second element is that there must be a borrower of the loan. The third element is the loan itself. And the last element of jual janji, which differs from the two other security transaction, would be there shall be collateral agreement, which is the kind of agreement that protects the rights of the borrower to purchase back the land that has been transferred to the lender as a security after the loan has been fully paid. In other words, the lender promised to resell the land back to the borrower upon settlement of the loan within a specified period of time that has been agreed between both parties. Besides that, it also restricts the lender to do any kind of dealings with the land when the time period for the payment of the loan by the borrower is still ongoing. Other than that, it shall be considered whether it is a purely contract or not. Likely the strict or the liberal interpretation, but one that is suitable with the circumstances given shall only focus on strict interpretation. Strict interpretation is the judicial opinion where the court shall strictly interpret the agreement made between both parties. The general rule for strict interpretation is that time is of the essence. If it is already stated in the agreement saying that the loan shall be paid in 3 months' time, then the court shall strictly apply what has been said in the agreement. Failure to comply on behalf of the borrower will cause the land that has been transferred to be fully owned by the lender, and the lender will also have the rights to make any deals on the land. To further strengthen and be the landmark case for the question given, shall refer to the case of Muhammad Isa against Haji Ibrahim, where in this case the first appellant had entered into a collateral agreement or jual janji with the respondent, in which the respondent has to accomplish all payment of loan to the first appellant within 6 years. However, 3 years later, when the collateral agreement was still in force, the first appellant subsequently transferred the IDT or title of the respondent's land to the second appellant, which effectively the respondent ought to contended that the appellant had breach of jual janji and made such a fraud action. Both High Court and also Federal Court of Penang was on the favour of the respondent, as the appellants do indeed made a fraudulent action to the said jual janji, as both parties vividly aware that IDT of the said land was the respondent's belonging, but they refused to acknowledge it as receiving sums made them blind.
So as to apply with the current situations, both Radi and Mr. Manilingam has entered into an collateral agreements. As an evidence, on 3 January 2013, both of them have an executed memorandum of transfer or MOT, but at the same time they also had entered into a collateral agreements or the jual janji, in which Mr. Manilingam in the execution of the agreement has agreed once Radi has give a full payments to the Mr. Manilingam must or obliged to give back the land to the Radi. So that's what has been promised to. As upon judicial review, in our circumstances, it only apply for strict interpretations but not liberal interpretations. Why is that so? Because by referring to the case of Haji Abdul Rahman against Muhammad Hassan, there is no intention to mortgage or intention to right to repurchase or right to redeem, as the clear cut of this intention both of the parties are to make it as a security of the particular agreements. So effectively, time is of the essence, meaning to say that both parties must comply with time given in the contracts and what they have promised in that particular contract, and neither of the parties, including Mr. Manilingam, can do anything beyond what he had promised to. However, the issue right now is when Mr. Manilingam, during the execution of 24 months when jual janji was enforced, he had entered into a sales and purchase agreements with Tora for 30,000 ringgit, and Tora has paid 10% as a deposit during the agreement. Because of that matter, you can consider to say that Mr. Manilingam had made a fraudulent actions with the jual janji agreements, because he had made beyond what he had promised during the agreement. He had said that during the executions 24 months, when Radis had paid the full payments of loan, Mr. Manilingam will retransfer back the land to Radis. But did he did so? No, he already made agreements with Tora, and right now that such particular land is on Tora, not on Mr. Manilingam anymore. And when I say that he had made a fraudulent action, it has been agreed with the court in the case of Muhammad Isa bin Haji Ibrahim, because that particular parties, especially the appellants, made the similar actions with what Mr. Manilingam did, and the court agreed to say what the appellants and Mr. Manilingam did is a fraudulent actions. But however, the argument do not stop there, because we also have to look on the third party perspective, which is Tora, because during the agreements, during the execution of sales and purchase agreement, surely enough, Tora have seen that the ITT's land is not under the name of Mr. Manilingam, it's under the names of Radi. But maybe perhaps that during the executions, Mr. Manilingam have said something or persuade Tora to enter that such particular thing, which make Tora such a reluctant just enter into the agreements without ever think that it is Radi's land. Due to that matter, it is considered to be as fraudulent actions too from the Tora's perspective, because he knows that it is Radi's land, but he reluctant to reject, but just agreed to pay the 10% of the deposit. So as an advice to Radi, as the proprietor of the lands, by referring to the case of Muhammad Hisa against Haji Ibrahim, Radi can make such agreement between him and Mr. Manilingam can be considered null and void, because Mr. Manilingam, as pursuant to the case of Husaini bin Yaakob against Tan Teo Sang, he does not clearly align with what the judgment has said in that particular case, whereby he must be understood under its terms and conditions, because Mr. Manilingam had broken what he had promised in the agreements and make such fraudulent actions by selling the land to Tora. Because of that matter, simply to say, Radi still have the right to that particular lands, and Tora, since entered into a fraudulent agreement, he does not have any rights about it. So in conclusion, for question number 1, Radi still have the rights towards that particular land, while Tora does not have any rights because of Mr. Manilingam makes such fraudulent action by selling the lands to Tora by fraudulent way, but at the same time, he had broken what he had promised in the jual janji with Radi. So that is all for the question number 1. Let's proceed with question number 2.
The issue in this question is whether June still has the right and interest over the land when she failed to comply with the terms and conditions in June's jual janji agreement with Lenny. Jual janji is one of the medium of security transaction to a sale of promise, whereby the person acting as a borrower transfers the land to the lender who will loan the money to the borrower. However, the agreement is only acting as a security because it is not transferring the full title of ownership to the lender. The concept of jual janji can be seen in the case of Tengku Zahara and Cik Yusof, where it stated that jual janji is a transaction to secure a loan without practicing usury or riba. There are certain elements that should be fulfilled in order for the jual janji to be valid. Firstly is the lender that shall lend the loan. Second is the borrower that will borrow the loan. Thirdly is the loan itself, and the last element is the collateral agreement that restricts the lender to do any dealings on the land and protects the right of the borrower to purchase back the land after the loan has been fully paid within a specified period of time. In pursuant with current situation, a strict approach will be applied. Under strict approach, in the collateral agreement, the borrower's right to get his land back will cease as soon as he failed to repay the loan to the lender in the time agreed. This can be seen in the case of Haji Abdul Rahman, where the borrower failed to pay the loan within a specified time. Thus, it was held that the borrower cannot claim his land back as the contract is a contract of sale, where time is of essence. However, as in the case of Uthman and Meg, the lender is obligated to transfer the land back to the borrower once the borrower has settled his payment to the loan. There are two exceptions to the strict approach. Firstly is the extension of time, where both parties agreed that the payment shall be extended to a new date and the lender cannot refuse to accept the payment. The best case that can be portrayed is in the case of Ismail Haji Lembong, where it was held that the borrower is entitled to repurchase the land as it had been agreed by the lender to extend the time to pay the loan interest. The second exception is evading payment, where the lender refuses to accept the payment within the agreed time. And there can be two ways that can be constituted as an act of evading payment, which are firstly, the lender himself avoids to accept any payment, and secondly, the lender inserts additional new terms that are not provided in the original agreement and not agreed by the borrower. And as in the case of Ahmad bin Omar, the court held the borrower is entitled to redeem the land as the act of the lender by avoiding to accept the payment constituted that the lender did not regard the contract as time is of essence.
For the current situation between Jun and Lenny, there is a jual janji between them because all the elements of jual janji is there. Jun is the borrower and Lenny is the lender, and as the borrower, Jun had borrowed the loan sum of 10,000 ringgit from Lenny, and Jun also had transferred her land to Lenny as the security of the loan. And in this case, there is also execution of collateral agreement between them. Since there is a collateral agreement between them, Lenny, as the lender, cannot deal with the land unless if Jun failed to settle the loan within the time frame agreed. As we adopt the strict interpretation approach in this case, so the general rule is time is of essence. Therefore, as the borrower, Jun needs to pay the loan and settle the loan within the time frame agreed. Based on the case of mine and another and May, Lenny, as the lender, needs to retransfer the land to Jun once Jun had made the full payment of the loan within the time frame agreed. By pursuant to the case Haji Abdul Rahman and Muhammad Hassan, if Jun failed to settle the loan within the time frame agreed, then Jun has no right to claim the land, as she has no right over the land. Nevertheless, Jun still have the right to claim the land upon full payment even after the expiry date, if this case falls under any of two exceptions. In this case, Jun failed to call Lenny to ask for an extension of time, so there is no mutual consent between them in regards to the time of payment to be extended. Actually, the failure to call Lenny is basically because Lenny is at her son's place, which is located in a remote area, and the communication is very difficult. Actually, Lenny already informed Jun about this, so there is no act of evading payment made by Lenny. The situation would be different if Jun asked for extension of time from Lenny before Lenny went to New Zealand, as in the case of Ismail Haji Embong and Lau Kong Han. There is a tendency that Lenny will granted the request from Jun for the extension of time for settle the loan. Since in this case there is no extension of time, so the exception cannot be applied. Before Lenny went to New Zealand, Lenny already left her bank account to Jun in order for Jun to be able to make such payment of the loan. The act of Lenny by leaving her bank account to Jun and informing Jun that she might have difficulty in contacting her when she was abroad both affirmatively shows that actually Lenny has no intention to evade such payment. If Lenny has intention to evade such payment, Lenny would act similar as what the defendant in the case Ahmad bin Omar and Haji Saleh has done. Since there is no actual act of evading payment made by Lenny, Therefore, the second exception also does not apply in this case. Next, in regards to the matter that the amount June needs to pay to Lenny is not the same as the actual amount that she borrowed from Lenny is considered as freedom of contract. Even though there is additional fee that must be paid by June to Lenny, that additional fee is agreed by both parties when they execute the collateral agreement. Therefore, it cannot be considered as an act of evading payment made by Lenny because Lenny did not insert any new terms to the original agreement between Lenny and June. And the additional fee cannot be considered as usury because based on the case Tengku Zahara and Teh Yusof, it will only become usury if the lender intentionally increase the sum rapidly due to the increase of market price. So to conclude, June has no right and interest over the land because she failed to make the payment within the time frame agreed and none of the exception is being applied in this case.
So that is all from us, Madam Asma. Thank you for giving us the knowledge of this particular subjects, but at the same time, thank you again for giving us the opportunity to answer these particular assessments. Thank you, madams, and see you later.